getting everything set up here.
Yes, ma'am.
Okay, this is People of the State of Michigan versus Samuel Bush Jr., docket number 18-608FC. This is the time set for hearing on the defendant's motion to withdraw guilty plea and to correct an invalid sentence. And I'll take appearances first for the record, please.
Kayla Crino, appearing on behalf of the people.
I'm Daniel Bremer. I'm here with Mr. Bush.
All right, go ahead, Mr. Bremer.
Okay, first of all, with respect to the motion to correct sentence, the prosecutor is right about that the sentence actually was corrected.
Why did you file this then?
Because I didn't get a copy of the corrected sentence.
It's
there a chance?
It's a docket entry.
Is there a chance I can speak?
No, I'm sorry. Mr. Bremer, go ahead.
Yeah, and as I was saying, I didn't get a copy of the corrected sentence, but that's right. That the sentence was corrected.
All right, go ahead with the rest of your motion.
All right. Well, with respect to the motion to withdraw the plea, I'm basing this on the Warren case, and they don't make any distinction between whether or not the defendant was prejudiced or not prejudiced. They just say that the defendant has to be advised of the possibility of a consecutive sentence. Now, Mr. Bush did not get a consecutive sentence, but it was a possible consequence, and I think he should have been advised of that.
All right, thank you. Ms. Crino, response?
Thank you, Your Honor. The defendant here argues that under People versus Warner, which is 505 MISH 196, that the trial court should have advised the defendant that it had discretion to impose a consecutive sentence. The defendant argues that because this did not occur, he should have an opportunity to withdraw his plea. And ultimately, the defendant's argument fails for two major reasons. The first reason is that Warren did not hold that in all cases, the trial court must advise the defendant when it has discretionary sentencing authority. Instead, it held that the trial court must give this advice, quote, in cases in which such advice is relevant. And that's page 218. Here, if the court didn't actually intend to impose a consecutive sentence, then the advice would, of course, not be relevant to the defendant because he would be in no danger of actually receiving a consecutive sentence. Second, in this case, the defendant is not entitled to withdraw his plea because he did not receive that consecutive sentence. Instead, he received the exact sentence that he bargained for, and thus he cannot be prejudiced by the absence of advice that this court had the discretion to impose consecutive sentences. And that summarizes my arguments. We filed a response. I'd be happy to answer any questions that the court has.
I don't.
Okay, thank you. Then
I'm sorry.
I was just going to say that we would request that you deny the motion.
All right, thank you. First of all, for the record, Mr. Bush is present. I did put him on mute because he does not have a speaking role in this motion hearing, but he is present and able to see and hear us. So if this were a civil motion, I would be issuing sanctions against Mr. Bremer for filing it because, first of all, I shouldn't have had to have wasted my time for even 30 seconds on this issue about correcting an invalid sentence. What happened was at the original sentence, I misspoke. There was a Killebrew agreement to 420 months, and the credit was 445 days. And on one or more of the counts, I correctly imposed the sentence that was bargained for, 420 months. But on one of them, I misspoke and substituted the number of jail days credit instead of the number of months. And that ended up on the commitment when it was brought to my attention. Of course, I knew that it was a mistake. I corrected it. There was an order correcting the error that was filed, entered, and docketed on May 7th of last year. So more than a year ago, that order has been a matter of record in this case. With regard to the motion to withdraw guilty plea, again, there is no reasonable basis for arguing that the defendant is entitled to withdraw his guilty plea, or that Warren, a case that hadn't even been decided at the time that I sentenced Mr. Bush, should somehow be applied retroactively in this case. First of all, by the very language of the case, it does not apply, as the prosecutor indicated. And second, if we're going to apply it retroactively, there'll be the greatest miscarriage of justice one could possibly imagine in letting people who never even got a consecutive sentence withdraw their pleas because they were not given advice that was not even required, because they didn't get a consecutive sentence and because the Warren case had not yet been decided yet. So it's really far-fetched, to say the least, to be bringing this motion. And then finally, the other reason is that Mr. Bush negotiated his sentence. So he can hardly be heard to complain that he didn't know that he could get a consecutive sentence when he bargained exactly for the sentence that he exactly got, and he did not get a consecutive sentence. So for all those reasons, the motion is denied. And I don't know, you want to prepare an order, Ms. Crino?
Yes, I'll prepare the order. Thank you, Your Honor.
All right, thank you. You can tell them at the facility there, Mr. Bush, that you're all set.